Under certain circumstances, I
It is on the list.
yes, Article 60. Under the circumstances, Lord, on that this application I have challenged the third challenge that is pending before what and the petitioner is railway part. Now, by this notice, he received a notice. May I hand up to you, Lord? Program of they were about throwing out on the street.
Bring it on record. File an affidavit. File a supplementary affidavit. File a supplementary affidavit. Bring. Sir, bring. They should. If you are terminated, why should you not vacate the? So file it. File it on supplementary. Then you mention. File it today. Then you mention. What due process, sir? A residential quarter service by virtue of service. So let us see. We'll see. You file it. We are not hearing it right now. You file it. You file an affidavit. Then you mention. You bring that fact on record. Serve it. Then we'll see.
I shall file a supplementary.
Then you mention. Yes.
But day before yesterday, I had submitted my lordship
Regarding written submission.
written submission. Today I am serving. Yesterday, my lord, I could not. Today, I have added, my lord, 4 additional judgments on the cut-off dates and 2 extra paragraphs.
4 additional judgments on which point? Cut-off marks.
Cannot be, my lord. The way, the manner in which this cannot be done. Number 1. And number 2, my lord, Tej Prakash Yadav, my lord, that was, my lord, cited. Additional 3 paragraphs I have added. I have not.
So if you have given it to them, no problem.
I must say, because there was a specific submission on my behalf that I will not.
That is why we observed that date. Maybe it's some better that beforehand you give the written submission, then you argue the case.
My junior said, my lord, that Mr. Mukherjee, learned senior advocate, my lord, representing our hard copy would be better first.
So give it to him, then we'll not take it up to, let it be called. If it is, we'll adjourn it.
It is not listed. It has not been listed.
Not listed. It was supposed to come today. Why it is not listed? Why it is not? Yes, file or no file. Once.
Your Lordship, may I be permitted to mention a matter?
हमारे पत्नी को रखा बच्चा होने के बाद आदमी का दबाव रेप किया। देखिए कितना बड़ा क्राइम किया। हमको मेडिसिन देकर के साइलेंट कर दिया, बोलने वाला नहीं रह दिया, दिमाग शुरू कर दिया। हमारा फेल काम है। देखिए हो गया है हमारा, तो यह आकर के 420 किया है, साहब जो हरा दिया है। आदमी ने खूब उसको शूट कर रहे। हम तो इतना हो गया, अपनी साथ देखिए साहब, हमको 420 किया है, यहाँ आके उधरा किया है। हमारा फाइनल ऑर्डर हो गया है। सबके लड़के साहब
His matter. 148. He's Who is he? Who is he? He's why is mentioning the person? Will you ask him to send his lawyer? He's represented by a lawyer. Why is mentioning in person? आप वकील साहब को भेजिए, क्या बात है बताएंगे वो। वैसे नहीं होता है ना, जब आपने वकील रखा है तो वही आएंगे, उनको भेजिए। क्या क्या सकता है, आप वकील रखे हैं, आपकी बात हमको कुछ समझ में नहीं आ रही है, आप तो सब चीज बोल रहे हैं दुनिया का। वो तो सारा केस खत्म होना है, सिर्फ आपका क्यों, सारा केस खत्म होना है ना। पता नहीं, वो देखेंगे जब केस कॉल होगा तब। यस
Your Lordship, may I be permitted to mention a matter? This is a matter of a CIF soldier who was released.
CISF.
Yes, Your Lordship, who was removed from his service arbitrarily. What happened? He preferred an appeal before Honorable Calcutta High Court, and Honorable Calcutta High Court, before the bench of Honorable Justice Partha Sarathi Chatterjee, reinstated his service with full consequential benefit. But what happened, Your Lordship, that order was challenged before the Honorable Justice Harish Tandon. Your Lordship, Honorable Justice Harish Tandon was transferred to Odisha High Court. Now this matter is assigned to Your Lordship's bench, Your Honor. So I'm just praying, Your Honor, for an urgent hearing for this matter, because the
Where is the
CIF
assignment? You have the assignment order.
Your Honor, it is there in the records.
We don't know. Are you sure?
Like file is there, Your Honor.
Make a
Your
note.
Lordship, this is FMA 904.
Make a note, include it in the next monthly list. Give the, if it is assigned, it will be included.
This is Your Lordship. 904.
Next, if it is assigned, list it sometime in the next month, July. Yes.
Justice Bhattacharya, may I be permitted to mention one on one application for inclusion in the lordship's list before Justice Prasad, and it has been assigned before Honorable Justice Prasad and Honorable Justice Bhattacharya. It's an application.
You have taken his lordship's leave for mentioning.
If your lordship, Honorable Justice Bhattacharya, may kindly give me leave to.
Sir, you are required to first mention it before the Mr. Biswas, and then when he agrees, then you have to this. We have to tell you how to do it.
It has already been assigned that before your.
But this is not the bench. We have to tell you this simple thing. Yes. What do you want? Leave to file. What is the difficulty in filing? Okay, we currently file it.
Item number 1.
I appear for the respondent number 1.
For starting an argument by Mr. Hunt, if you submit one sentence, that yesterday, state judgment, order passed by the tribunal, state government is being also filed one communication. Now with the process tomorrow.
Is going to file, has not been filed yet.
Because they will return because
The order was passed on 29th January, my lord.
So should we dismiss it right now?
No,
Let it
no.
come, then only you will make the submission. Why do you want to, when they are saying they are filing? Yes, we are informed by the learned AGP.
Item number 3.
My appeal, Lordship. I'm being led by my senior, Lordship, Mr. S.N. Mukherjee. At the cost of being reprimanded, my lord, I'm praying for an adjournment. I've circulated this request last evening to my other side as well.
You mentioned for listing of the matter.
Lord, this was fixed today for hearing.
And when it is coming up, then you are seeking an adjournment.
My lord, my senior, he is unavailable and he's requested me to request your lordship.
Yes, take down. Upon mention.
Item number 4.
My lord, I'm appearing on behalf of the respondent, my lord, seeking 1 week accommodation, my lord.
1 week.
1 week, my lord.
Where is the petitioner? You are for the respondent.
Respondent, my lord. Lord, I've Mr. D&I was appearing on behalf of the my lord petitioner. I have informed, my lord.
You informed him, then why he is not here? None appears for the petitioner.
Item number 5.
Item number 5, my lord.
Yes. Item number 5, my lord, I'm praying not this week, my lord. Today I'm praying for not this week. Now tomorrow I have some issues, my lord. Friday, my lord, I may not be coming, my lord. Lord Shatra is there.
Filing of?
I'm seeking only not this week. Let that be on Monday or any other day, my lord. Not this week, I'm seeking.
Yes, straight list.
Item number 6.
My lord, I have
I have further respond this matter, my lord. My lord,
my lord, liberty was granted to file supplementary affidavit, my lord. Day before yesterday, this was taken up, but that is now for the EPF was not there. So my lord has returned this affidavit.
File it.
And file it today.
My lord, we want to file.
You have given a copy,
Yes, copy.
supplement.
Mail or there.
So for filing opposition,
It's not the 3 weeks.
2 weeks time is prayed for.
Item number 7.
My lord,
Hearing for Union of India, this matter, Lordship, I am praying for not today, Lordship.
Yes.
Item number 8.
I'm praying for short Passover. Mr. Pratik Majumdar, Learned Counsel, is appearing in
Today, call the next.
court number 11, Your Lordship.
9.
So many cases have.
Item number 10.
Legal behavior.
Learned Counsel, Ajit Kumar Mr. out of session. Kindly not today.
Call the next.
11. Item number 12.
Praying for short Passover, man.
Not today. The next.
Not today.
13. 14.
Your Lordship, I appear for the appellants. I was praying for 2 weeks' time. My senior is unavailable out of Kolkata. So on that ground, if it could be out, if it could be after 7th of July.
It's coming for the first time.
Your second date, first date, the petitioner respondents had taken time. New motion.
So that means effectively it is being listed for the first time.
Your Lordship. This is Air Force matter regarding disability pension.
As prayed.
My lord, my lord,
Call the next case.
my lord, item number 10, kindly make.
Call the next case.
15. 16. 17. 18.
18, I am appearing on behalf of the state, Your Lordship.
Is appearing today. Not. There's some commotion outside.
Five, na?
For the none for the petitioner. 2 weeks.
Nineteen.
Why nobody is appearing today?
He studied and the bench was not available. Sir.
Huh?
Said the bench was not available. That's it.
So today they will not appear. You are filing the opposition. Let them be here. Not today.
My lord, item number 11, my lord.
Sorry, matters which
My lord,
have.
I was there, my lord. My lord, I was there.
Sorry, madam. Not.
My lord,
This cannot be done. I will not permit this.
20,
There is a way for mentioning these things at the time of rising. These are well established precedents in a court. You can't just stand up before any case and say that my case has passed. That's not the way.
20 is being called. Down.
Okay. Not today, call the next.
Direction to file affidavits. We have filed. Since my learned junior is not there.
Is it served?
Yes, I have served. I can see an endorsement. It's served.
Affidavit of in opposition is being filed.
Item 19, my lord.
21,
Call the next.
22,
Straight away the shouting comes.
So the continuing matter that already I have submitted. Before going to the issuing order, kindly come page 22. That is the appointment letter issued by the.
What is the issue? Just tell us first.
The issue is, thus if the petitioner's mother was an employee under PWD under, according to the post of work guard, and it's the charge employees.
Post of
Work guard, work guard, work, it is written work guard.
work guard.
According to the respondent, as the mother of the petitioner was a work guard employee, he was not a permanent court. So my prayer of the compulsory appointment is rejected, relying upon all subsequent notification which were issued after the death of my mom.
And you are relying in support of your claim on which circular or policy?
Prior to the date of my mother expired.
Yes.
All circulars have been relied, all 2013.
Please.
Sir,
Please. So 11/4/12 is the date of death. And you are relying on which policy? Show us.
Now, also before that, also I'm just coming. Kindly come page 24.
What is it?
Page 24. Also the issue in this
in this Lordship, the WPST, that my application has been turned off on the ground that my mother was a work charge employee, but my case has not been considered that so far the other work charge employees who were appointed long back ago, even at the time of my mother, all have been regularized as a permanent staff. Now, Lordship, my mother also discharged her duties for a period of long time, more than 10 years. But my mother, Lordship, the appointment, my mother's service has not been considered as a permanent employee, which has been Lordship overlooked by the.
So therefore, your claim is based on an assertion that you ought to have been regularized, which has not been.
Because Lordship, kindly come page 24. In terms of this notification, Lordship, work charge employees at page 25. A huge number of work charge employees.
No, but the issue before the tribunal was not one of regularization. The issue before the tribunal, which we are considering in judicial review, is your claim for compassionate appointment.
Compassionate appointment.
Was there any prayer for regularization?
No. So already my mother expired. Now,
So therefore, that issue is not open now.
Now, Lordship, my mother's service, my submission is my mother's service ought to have been considered that as we already completed the 10 years of service.
Under which policy, therefore, we are asking you?
Yes,
24. What policy dated?
This is superintendent work charge assistant as per the annex list, who have completed more than 10 years of service in their present post on 31st March 87 are consequent on their post being converted into the permanent under the regulation of the establishment effect from 1st April 1987, pursuant of the order subsequent order of the Finance Department. I F 491 dated 8/1986 Road Department ordered that such and such are hereby subsequently appointed and confirmed 1st April 1986. The regular establishment under the work charge establishment hereby abolished from 1st April 1987. The pay of the absorbed permanent work assistant shall be known at the rate of the permanent staff under the regular establishment.
So, your mother was in service since which date?
My mother was service since 1991.
Then how you are relying on this 87?
They have again, the kindly come.
See, we are not considering your claim for regularization because there is no such claim in the OA. It cannot be raised here. Be very clear on that. In the OA, your only claim is for compassionate appointment. No claim for regularization. Therefore, we will not enter that arena.
Just kindly record my submission.
Yes.
Kindly come to the page 36.
You can.
The notification of 2000. Even 2000, they have adopted a policy for regularization of work charge.
There is no claim for regularization, sir. How you can make submissions for a claim not raised in the petition?
They have regularized.
We are asking you a different question. You are trying to take us on the issue of regularization. Before that, we are asking you, can you argue something not raised? Let us address this issue first.
My contention is, it was the action of the authorities is under a violation of Article 14 on the ground.
No.
Yes, on the
There is no, come to page 80 of your writ petition. Come to page 80 of your writ petition. Yes. There, see the relief you have prayed for. Please see. Please. That's all. Nothing beyond that. There is no question of arguing the issue.
Considered as a work charge employee.
Sir, that we know. that you do not dispute, you do not raise any issue. You say, even if she is work charge, give me a compassionate appointment. Therefore, we ask you under which policy it is to be given. Now you say she ought to have been regularized. That is not an issue in the OA. Therefore, we will not go into that issue.
Kindly come page 112, which is the impugn order. Also, the prayer of appointment on compulsory ground in favor of the OBG Sarkar, the petitioner hearing attached to the highway division under Western Highway Circle 1 Public Works Road, Calcutta. The scheme of appointment on compulsory ground is being regulated as per provision breakdown 2030. Now, this regulation is after the death of my mother.
That is immaterial. You are making a claim, you have come to the court. They have not come to the court. So on what basis that we are asking you, on which policy you are relying?
Prior to 2013, there is a 2012 policy is there.
So therefore, let us see under that policy whether work charge is entitled or not. That is what we are asking you. 2012, what is the EMP number? You have the number.
Sorry, 2008 policy, lots of notification dated 2nd April 2008. You have come with this notification. At present, appointment of compulsory ground of the dependents of the state government employees who die in harness, he returned permanently on being declared permanently incapacitated for service. But we kindly consider this compulsory.
We have it. We have it. Which clause in this 2nd April 2008 you are relying upon?
So 2.1. One of the dependents of the government employee who died in harness who returns permanently prematurely on being declared permanently incapacitated may be offered appointment on compulsory ground. The family of the deceased or the retired employees, as the case may be, in need of immediate assistance and the employee had at the time of the death of premature retirement, provided that in case of appointment of a dependent of a government employee who retires prematurely on being declared permanently incapacitated, all others condition laid down in para such and labor department notification such and such. For the purpose of appointment compulsory ground, the dependent government employee shall mean wife, husband, son. I'll also kindly come clause 2.2. Unmarried daughter employee who was solely dependent on the government employee. One of the conditions needed to be fulfilled offering appointment on compulsory ground is the family of the deceased of the prematurely retired employee Lordship is in need of immediate financial assistance. It is hereby clarified. Now, Lordship, kindly come. My application was recommended that I am suffering from acute economic conditions.
He making all these submissions will not help you. Therefore, we are asking you, the core issue is work charge employees, legal heir, whether entitled or not. You may be in penury, you may be a destitute, that's not the issue.
Now, Lordship, they have
The entitlement you have approached based on which, that is why we are asking you repeatedly on which basis you have approached for this benefit. Which circular is helping you? 2008 is for government employee. Your mother was not a government employee. Government employee is defined. Government employee expression is already defined.
No, Lordship, here in this case, I join issue.
Yes.
That what church employee, Lordship, kindly come. I receive the benefits of the pay benefits. I have received my mother subsequently received all.
So there is no circular that you are relying upon. Let us be clear on this. Then whatever you want to say.
There is no such.
All right. So there is no circular. Then how you can get the?
My contention is the petitioner case ought to have been considered.
That's not your claim. Sir, that is not your claim anywhere. Why should we go into that? That's not your claim. No, where have you said? Show in your OA. Show from your OA.
Kindly come my application.
Read from your OA. Your only prayer is to grant compassionate appointment. You don't say that she ought to have been regularized, that she has put in enough service, there was some circular which she has missed. Nothing of that sort.
Yeah. Kindly come page 76.
Why relief is at page 80, sir? There is no such relief. Why are you taking us to page 76? You may say everything. Compassionate. That is why we are saying. Therefore, we have to see whether the tribunal has committed error.
No, kindly come page 79. That's the relief sought for.
Yes, 79. No, it is at page 80. Yes.
If the respondent cancel, resign, or set aside the interim order and revisit the case of the applicant strictly in accordance with law. Direct the respondent authority, their main agents to immediately accord appointment into the compulsory ground. All required formalities under the law and cause him to join the court. Direct the respondent authorities to produce or cause to produce the report and further. I think prayer was for giving appointment on the compulsory ground. Now, Lordship, my contention is, first contention is, Lordship, the timing down page 84 is a service purpose.
For what?
Service purpose prepared that my mother was a permanent employee. Again, so kindly come page 86. Kindly come page 89 because the pay fixation made in her favor. She used to draw salary as like as the all permanent employees. But to kindly come 12 July 2000 office order, that's at page 106.
Did you file a reply before the tribunal?
They choose not to file. That is the order. और डिवीजन में जो है
No, it is what he is saying is the service book, we can see it. Work charge employee are placed in a scale of pay.
excellent. Appointed you in they work with a particular job.
What we are asking you, do work charge employees get a scale of pay and RUPA rule and benefit under the RUPA rules? They do. Even work charge employees.
That is the not retrospective.
That is?
Not retrospective.
No.
112, 22. I have annexed. How an executive order has been retrospective effect.
Sir, first you have to establish your claim. He is saying that even work charge are allowed a scale.
Lordship, the government,
Therefore, the fact, please have some patience. So therefore, if a scale is paid to you, that ipso facto does not make you a permanent employee. This, you have drawn our attention to the service book. We have seen it. They say this is given to work charge employee. Is there any order placing you in the regular establishment? If not, then again we are asking you, how can you get the compassionate appointment?
they have treated me as a permanent employee.
Where is the question of treating? It is not at their discretion. Compassionate appointment is always under a scheme or policy, because you know it is an exception to the general law of appointment. Therefore, unless there is a circular policy based on which you can assert your claim, we are repeatedly asking you which policy allows for work charge employee to get a compassionate appointment.
Kindly come page 122A.
112.
122A. This learned tribunal has relied upon memoranda.
We are asking you, you are relying upon which? Forget about tribunal. That mistake, if it has committed, how it will help you? You have to assert your claim. You have come to the court. They have not come to the court. So on basis of which scheme you are claiming? Tell us. So then we will take it that there is no scheme or policy based on which. Either show us. Therefore, we are repeatedly asking you.
This is a law of the land nowadays.
Now show us. Not nowadays. Ever since compassionate appointment has come into existence, this is the law. That it can be only under a policy or a scheme. So which policy? Show us.
The policy, whatever the policy of compassionate appointment was prevailed at the time of death of my mother, I am relying upon this policy.
So which one? Show us. Where? Which one says? Which one says that work charge employees dependent legal heir will get the employee?
Now also this is the work charge and two also the factors. That is the work charge employee and permanent employee.
Yes.
Now my contention is, my mother, by issuing the service books and all the benefits of pay benefits,
yes,
mother has been considered as a permanent employee.
All right.
Now,
very good.
My senior friend, that work charge employee, as per the order of the Honorable Supreme Court, has been debarred from regularization. But the kind that is so reliable order. Kindly come to 122A of my application. Engage in regularization of the employee in the work charge establishment under setup of various departments. The understand is directed by order of the government state that the government take that. Engagement of work charge staff under each department can be made without a prior approval of the finance department. Consequently, the judgment of the Honorable Supreme Court delivered in the case of State of Karnataka versus Suma Devi and others, and subsequent decision of the Honorable Apex Court, the further direct state that regularization of the work charge staff is not possible at this stage, according to provisions contained under the Finance Department's memo number such and such. Operative, the order shall take effect immediately. This order was passed on 20th July 2011. Prior to that, prior to the date of 20th July 2011, my client already completed 10 years of service and treated as a permanent employee.
Yes. Yes, you should file a opposition. Yes, take down, let the affidavit in opposition be filed.
So last occasion I have filed me, sir,
Yes, affidavit of service taken. We are asking you to show you are unnecessarily taking us here and there. Yes.
Twenty-three,
Not today.
24,
in this matter, Mr. Arjun Rai, appearing for the petitioner. He has not come to the court, kindly someone.
Not today.
25,
Well, this is the affidavit of service. Have served all the respondents. Now, the case of the petitioner is this, my lord. The petitioner before lordship is, my lord, a physically handicapped candidate, my lord, having 40% of, my lord, visual impairment. Now, my lord, he is working as assistant inspector of school in the school education department. Now, my lord, owing to this, my lord, his physical handicap, the condition that he is in, my lord, he made representation before the authorities, seeking, my lord, to get transfer to nearer to his place. My lord, as of now, he has to travel more than 45 kilometers, my lord, and there are 3 big journeys he has to conduct to only to get to his office. So he made a prayer before the authorities, my lord, seeking, my lord, transfer to a nearby places. 3 places were mentioned, my lord, so that he can be accommodated there.
You are posted at which place?
My lord, I'm presently posted at. Just a minute, my lord. Just a second, my lord. I'm just showing.
Lalbagh within district Murshidabad.
Yes, my lord. Lalbagh within district Murshidabad. I'm posted. I will be seeking.
Lal Bagh.
Yes,
Lalbagh, my lord. This is a circle, my lord.
Lal Bagh in which district?
Murshidabad.
Murshidabad.
Please allow him. We'll hear. Yes.
It's
No,
in
he was
Murshidabad.
not saying. That is why I wanted to help the court.
Please allow him. He is addressing us. He will tell us. Yes.
My lord, I'm in Murshidabad, my lord.
Yes.
But thereafter, what has happened, my lord?
And he has given a choice of 3 places.
I have given a choice of 3 places to the authorities concerned to transfer me so that I can, my lord, commute, my lord, without any hindrance.
Yes.
Now, my lord, this being the situation, my lord, I approached the Commissioner of School Education and the Principal Secretary. Now, my lord,
They have rejected your claim.
my lord, they said nothing. My lord, they kept mum. I may say, my lord, stoic silence was maintained by them. I moved the commission for, my lord, the persons with disabilities. My lord, this is a commission. My lord, they also send the thing saying this my representation to the concerned commissioner and principal secretary, stating that in terms of the, my lord, Disabilities Commissions Act, my lord, I will be, at least my case should be considered. At this juncture, my lord, nothing is happening, my lord, I moved the tribunal. Well, the tribunal by its order date, it said, as if the tribunal order says that I have challenged the transfer order. Your lordship kindly have a look at the impugned order of the tribunal. I never challenged any order of the transfer.
Where is your prayer? OA
Okay,
prayer?
the prayer in OA is at, my lord, page 32. There are also government circulars, my lord, of the DOPT, followed by, my lord, a circular of the Women and Child Development Department. And, my lord, followed by those, my lord, there are two circulars of Health Department and, my lord, Higher Education Department. But there is no such circular with regard to school education, I must say, my lord, that's not there.
And where is the memo of 25 to 2004, which you are relying upon?
My lord, page 41, if your lordship takes up. Now, this is a memo of, my lord, the Health Department.
Yes, just let us see.
Page 41, lordship has got it, my lord. My lord, it speaks of the 90 memo, which is also annexed. Second paragraph, and, my lord, III would be relevant in my case.
In this project. It says, provided there is a scope. You are in the Health Department.
Well, I'm in school education department, my lord, but your lordship takes up page 42. There is a memorandum of the Higher Education Department, my lord. Although, my lord, all the memorandums speak of, my lord, the Women and Child Development Department has, my lord, if your lordship takes up page 41, my lord, it's the very first paragraph. In pursuance to memo number such and such, my lord, that is the DOPT memorandum, my lord, such and such from the government of India.
Endorsement to all departments.
Yes, my lord. That says, my lord, the grievances, Ministry of Government of India, Ministry of Personal Public Grievances, Pension, Department of Personal and Training, and the Government of West Bengal, Women and Child Development and Social Welfare Department, endorsement to all departments of the Government of West Bengal with a request to make suitable departmental order. The Health and Family Welfare Department, Government of West Bengal has decided to issue under mentioned order. The posting and transfer of the following employees under the administrative control of the Health and Family Welfare Department, Government of West Bengal, will be made to the working places nearest to the respective families at the choice of the employees concerned, provided there is any scope for purpose. Number point one,
And this is to be done at the level of the principal secretary.
My lord, I am a Group A officer, my lord. Now, my lord, in terms of the CCA rules, an amendment to the CCA rules, my lord, only the pay scale denotes my grade. My lord, pay scale is as because I am a Group A employee, my lord, it has to be to the principal secretary. My lord, although commissioner can do that, my lord.
What are you working as?
Assistant Inspector of Schools.
Yes. Yes, sir. It's not a case of transfer. He's not challenging any transfer order.
No, the order is palpably, my lord, wrong.
So you just consider
Has to be considered. It is
your
going
pending his pending application. It should be
to
considered.
be considered. And the tribunal proceeded on a wrong footing as if he is.
Yes, that's not the fact.
This is the case where in 2021 he was transferred from.
He has joined that place, but he is saying I am finding difficulty in attending the office.
So in the same district, let the department proceed.
We don't know because this policy says provided there is any scope for the purpose. So you
My
will
lord, my
consider.
lord,
Yes. The
I never wanted to obstruct the court. I wanted to assist the court.
No, but when both speak, for us it becomes
So
difficult.
he stopped. I thought he.
All right, yes.
26.
My lord, item 26, I beg to appear on behalf of the petitioner. If your lordship permits me, my lord, to my lord, appear virtually, or otherwise, my lord, I can come
Who
back.
is assisting you?
My lord, the advocate and record is also not present, my lord. This is little.
All right, you address. We are not. We welcome you to appear online. That is not a problem.
No, because my lord, generally assisting your lordship physically is much better than virtual. My lord, anyway, my lordship, the last annexure that happens to be the order impugned. My lord, the recording is that since I have not participated in the selection process, I cannot, my lord, challenge any, my lord, anomaly in the, my lord, advertisement that, my lord, initiated the selection process. My lord, that was the finding, and that is how I, my lord, my way was rejected. Now, my lord, my case is very small. I, my lord, intend to appear in the selection process for the lecturer of homeopathy, my lord, lecturer, homeopathy medicine lecturer. Now, my lord, the rule speaks about qualifications which doesn't specify any teaching qualification, but the advertisement says that marks will be awarded to a person who has teaching qualification. Now, my lord, these marks allotment will, my lord, restrict my entry into the selection process. So I didn't participate in the selection process because, my lord, our understanding is that, my lord, if we participate in the, my lord, selection process, I cannot turn back and, my lord, challenge the selection process on a subsequent time. So that's why I will take your lordship to the advertisement. Page 74 is the advertisement.
দেখেছি कुछ हाँ দেখেছি
Now, my lord, page 75, 79 subsequently speaks about the distribution of marks for recruitment to the post of lecturer in West Bengal Homeopathic Education Service.
Where is the notification of 25-24?
25-24.
20th May 2024.
My lord has 28-24. My lord, that was an, my lord, my lord, I should have made the submission on the prior occasion. That was, my lord, the selection process, the interview was called. So, my lord, we approached the tribunal for an interim order, and we also approached before this honorable court. My lord, at that point of time, it was stated that the selection process is already over. Only the list is to be declared. The final appointment has to be given. At that stage,
No,
my
no,
lord.
if you have not participated in the process,
yes,
how can you raise an objection to an interview being conducted in the process?
No, my lord, that is not my case.
Come to page 133 of your brief.
Yes, my lord, that is, I stated that you don't publish the result.
Why for someone who has not challenged the process and not participated, why they should not publish? That is the issue.
No, my lord, that is not the
Someone who
issue.
has not participated and someone who has not challenged the notification by which the recruitment process was initiated.
I have challenged that.
Huh?
My lord, I have challenged that notification.
Where is
That
that?
is in my way.
Show us.
That
Where
is
is the
in
challenge?
page 74. My lord, kindly takes up my way. That is my challenge. That was an interim protection I prayed for. Because, my lord, I thought that if the, my lord, selections has been given, then my lord, the parties who will be prejudiced subsequently if the advertisement is set aside will, my lord, increase. That's why, my lord, I challenged.
So you have filed two ways.
No, one way and one application. That application part is over because it was held by your lordship that cannot be done at this stage. So it was remanded back to the tribunal with an, my lord, request to the tribunal to hear out this matter expeditiously. My challenge is at page 55, the prayer in my way. I'm sorry, my lord, page 53 it starts from. I have prayed specifically for setting aside the advertisement dated 16/10/23, stating that there has been a restrictive clause imposed, which, my lord, dehodes the rules of the rule-making authority. And that is why I didn't participate and I stayed out of the selection process to challenge the advertisement.
Where is the advertisement?
My lord, kindly takes up page 74. And page 79 is the qualification part.
No, no. What is the last date for the application?
The application period is over. My lord, I challenge this advertisement stating that this dehodes the rules and the rule-making authority cannot travel beyond the rules.
Please, you
in
have said
putting
that
in a
thrice.
restrictive
This
clause.
is the third time you are saying that. That we have understood. We are asking you, a notification
sorry,
was
my lord,
issued for the
have repeated.
recruitment process on 16/10/23. You challenge that notification saying that I am an intending candidate.
Yes.
And I am offended by some
Yes.
restrictive clause. So are you required to assail
Yes.
it before the last date for making application, or you can make it at any assail it whenever you like?
No, my lord, absolutely. I bow down to your lordship, my lord. This is the point that I should have, my lord, mentioned at the prior occasion, my lord.
So
I have,
therefore,
my lord,
what if we are
given
asking you what is the last date for making of application?
my lord, this last date of application is stated here, my lord, in page 78. That is
Page 70?
over. 78.
8.
23rd September 2019. That is over.
No, no, it
Admittedly,
can't
that
be
is
19. It can't be 19. It's a advertisement of 23. It can't be 19.
I'm sorry, my lord. This is what this the same advertisement. It
No,
is
no, you
absolutely
are saying that there is a variance between the 19 and 23 advertisement. Therefore, you have annexed the 19 advertisement also.
yes,
Now,
my lord. Yes, yes. I will point out. I'm extremely sorry, my lord. I will point out.
May I very humbly submit before your lordship? Kindly takes up page 75 once.
no, see, we have seen that November 23. We don't know whether it has been extended. So we are asking him to give us the last date.
Extended, your lordship, as per my instructions, till the 20th of December 2023.
2012-23.
Yes.
And when the OA has been filed?
It was initial.
2024.
OA was filed long after that, my lord.
Then how you can assail this? What is
My
wrong
lord,
with the tribunal's order? Just come to this issue. Then we'll go into the merits whether the advertisement is having an offending clause or not. Can you assail it after the last date and say that you were an intending candidate?
My lord, I made a representation also. My lord,
Sir,
anyway, that is
please,
not the issue. Yes,
please.
yes. My lord, I should not. I should
Please.
not make the submissions. Absolutely.
Yes.
Yes. My lord, so far as this point is
What is
concerned,
the law on this? Show us the law.
My lord, your lordship will grant me 2 days time, my lord. I will come back physically and, my lord, satisfy your lordship on this
The
point, my
short
lord.
issue arising for consideration.
Grateful, my lord.
Your lordship.
Twenty-seven, my lord, I appear for the petitioner. This is a matter, my lord, your lordship was dealt with this very petitioner in the earlier round of litigation. Matter relates to, my lord, NOC of a doctor. Now, my lord, that the earlier occasion, my lord, that was NOC for a post of Kollani, doctor in the post of Kollani. Your lordship has allowed that petition, my lord. Thereafter, he participated, could not qualify. Now, a fresh recruitment process was taken out by the All India Institute of Medical Science, Kollani. Now, my lord, at that juncture, the petitioner made an application before the authority seeking NOC in terms of his earlier order passed in, my lord, in the earlier writ petition, my lord, that is WPST 217 of 2024. No, my lord, nothing happened, my lord, that compelled the petitioner to move the, my lord, the London West Bengal Administrative Tribunal, my lord, seeking a NOC from the authorities. Now, my lord, even been the order of this very petitioner in the annex in the original application, still, my lord, the learned tribunal, my lord, practically abrogated its power and sent the matter to the authorities for consideration. My lord, your lordship may take note, my lord, there is a clear-cut Supreme Court decision on this, my lord, which says the learned tribunal should not, my lord, abrogate its power and send the matter for consideration before the authorities. My lord, but this is also a matter relates to, my lord, West Bengal Administrative Tribunal, wherein the tribunal, my lord, abrogated its power and sent the matter for consideration by the authorities. But the Honorable Apex Court has, my lord, decried that procedure. Now, if your lordship allows me, I can produce those judgments, my lord. Now, my lord, what has happened?
So is there any last date for giving this?
Now I'm being told, my lord, today petitioners might be coming, my lord. 1st of July is the date fixed for, my lord, the interview process. And by that time, I required, my lord, I couldn't prepare the can. But yesterday only, my lord, my advocate on record has been informed that they have given a list that 1st of July is the date fixed. So, my lord, that being the situation, my lord, I can file a can, my lord. The clients are coming, my lord. To be very candid, my lord, today matter is appearing in 27. We hope that it could have been taken up to the latter round. So, my lord, he is coming, my lord, that is the issue. Now, my lord, if your lordship kindly takes up the Supreme Court order, my lord, which clearly deprecates such practice by the tribunal, but time and again, my lord, tribunal is doing the same thing.
The tribunal has directed to pass the order as per the High Court judgment.
Yes, but now, my lord, what they
Pass.
passed the same order.
Where is the order?
Can is there, my lord, can 1 is there. Same order, same reasoning, which was there in the earlier application. Same reasoning, my lord, doctor of doctors, if we leave, he may get, your lordship got the can, my lord. My lord, your lordship will find page 11. If your lordship sees the earlier order, my lord, more or less in parameteria, same order which your lordship has deprecated. This very bench has deprecated, my lord. Again, the same stand. It might come as contemptuous also, my lord. The court's order has been flouted in this manner, it's contemptuous even. If your lordship takes up your lordship's last order, exactly same, my lord, that is annex, my lord, page 69. Page 69, your lordship will find an order dated, my lord, 26th of November 2024, passed in the same petitioner, Dr. Anand Kumar Gal. Now, your lordship kindly takes up, my lord, the stand they have taken in this scan, my lord, is absolutely identical. Well, your lordship will find your lordship's findings at page 73, paragraph 7. Page 73, paragraph 7 of your lordship's order. But the rejection order has also been put to challenge by way of application bearing Can 1 of 2024. The stands taken and the grounds urged in the present proceeding by both the parties is the same, which has been urged by before the tribunal as noted above. The state authorities continue to take a plea. Insufficient number of doctors in state health service and larger public interest being served by retaining the petitioner in the state government service. The petitioner contends there is no statutory under which he can be forcibly retained and made to serve the state government service. There is also no criminal proceeding, no departmental proceeding or government pending outstanding against him. What is the petition now?
So where is this fact on record that by 1st of July you have to
Today he will be coming today, my lord, to affirm it. My lord,
bring it?
Monday, my lord, I will affirm. I can file a can, my lord.
Monday is first.
Monday
Monday.
is 30th.
Why do you in every case we find that on the last day you are doing these things? Why?
Your lordship may fix it tomorrow itself, my lord. Tomorrow is
Let them have it and we'll see what can be done. We don't know how they pass such orders, what kind of, how they can do this. It is very difficult to understand. How can you reject the case on the same order which is rejected by the High Court in number of cases?
public health care.
So once it has been rejected, you will take the same ground again. Substantially, your reason is the same. Insufficient, doctor. What? No.
Medical Council of India, 3,600 students.
Whether it is 24, whether it is 84, that is not the point. The point is how you can take a reason when it is rejected already. And where has this officer considered the High Court's order in the rejection order? Just show us. The tribunal has asked him to consider the High Court's order passed in WPST 217 of 24, where it has been considered. He is ignoring the High Court's order. Obviously. Because he knows if he considers he can't do this. So he ignores it. This is permissible. So can you do this? Then he has deliberately, it appears, he has ignored the judgment. Huh? That you have already said. We are asking you, look at the conduct of this officer. You are before the High Court. He is ignoring the order of a High Court. He has ignored. Now, whether anything else is required for us to proceed in the
No, he has no authority to. No, I'm saying that. But this order has been passed. That's the. Yes. No. What are that?
kindly see order of the tribunal. It has been submitted by both inform that WPST number 2174, Honorable High Court had directed respondent to issue no objection certificate for participation in the selection process conducted by the AIMS under advertisement number 10 July 2024. The applicant had appeared in the selection process but was not successful. Kindly see. 217/2024, this court allowed to appear in the, but he was not successful. And here he wants to appear in the interview for appointment of at AIMS at Kolani. But while passing this order, the learned tribunal, education department got to consider the representation, not considering that. Can you see the language? Having heard the submissions considering the facts of some case, they have proceeded direct the respondent number 4, Director of Medical Department of Health and Family, to consider within 6 months the representation filed by the applicant 9th March 2025, issuing NOC to enable him to appear in the selection process interview for the post of Professor Orthopedics, All India Institute of Medical Science, AIMS in Kolani, in terms of advertising numbers such as that. While considering the representation, the Director of Medical also rely on the High Court's order to avoid the final decision coming. He ought to have been considered. No, I'm not saying that. What is the facts that I'm placing? They are the executive.
Necessarily generating unwanted litigation. The same issue has been decided in the same petitioner's case. The tribunal asks you to consider the High Court's order and you don't consider it. And then you say that he should go to the tribunal.
I'm not saying that. This has happened. I'm saying that. Yes, in terms of the order of the tribunal, order has been passed. Order are good or bad, I'm not saying that. Whatever order has been passed, that has been placed before your lordship. If we do not comply the tribunal order by considering his case, then I will be held up for contempt. But whatever is considered.
It is not contempt of the tribunal's order. It is the High Court's order which you are required to consider, which you have not done. There is no contempt of the tribunal's order.
No. So far,
there is whatever you have failed to take into consideration the High Court's order. Why should you ignore the High Court's order? That is what we are asking. You place that fact on record. We'll keep it tomorrow.
Tomorrow at 2 o'clock, so that he can come along.
Tomorrow, yes.
Next two matters same. Same issue, same petition approach earlier, only with the third one is different.
Item number 28.
Yes. Yes, same question. How can you do this? Therefore, we are asking you, how can you do this? It is?
Doctor.
That is not what we are asking you, madam. We are asking you, how can you ignore the High Court's order while passing the order? We are not whether you have sufficient doctor or insufficient doctor. That is not our concern at the moment. Because we are not going to re-decide the same thing in every case. So we are asking you why the order has been ignored in spite of specific direction by the tribunal. We want reply to this, not how many doctors you have.
Not direction for affidavit.
Huh?
Not direction for affidavit to justify. And the record the pair for affidavit has been rejected by a lot. Only this one. The lordship may allow the application, but if
the learned counsel for the petition.
I stand corrected. There are 3 days or 3 incumbents. If you get to the last one, which is Lordship has passed an order, that is fixed on 3rd of July. That is fixed on 3rd of July. Instead of 1, it will be 3rd. Okay.
I've said that
29. 28 years. Similar matter, 27
सब डॉक्टर भी नहीं कर रहे डॉक्टर भी क्यों
28.
My lord, I am appearing on behalf of state in item number 28, my lord.
Yes.
70.
What was the WPST number? In 28, same order, WPST number will change.
Lord of Chair. Targeting.
Just as played list of same case.
I am for the petition. This matter pertains to the pensionary benefit as well as the family pensionary benefit upon condonation of shortfall of service.
How much?
nearby 3 years.
3 years.
11 months.
7 years, 11 months. That means nearby, not 3 years, I say. 2 years.
2 years, 11 months.
7 years, 11 months, what?
It's about 3 years.
Almost. No, 7 years, 11 months means 2 years, 1 month.
2 years, 1 month.
What happened? The husband of the petitioner.
So under which provision this can be done?
Yes, it is covered by your lordship's judgment on the self-same footing. That is why, initially, the husband of the petitioner was appointed in temporary basis with effect from January 4, 2001. Initial appointment, temporary basis 81.
Date, please.
In the post of Khalasi.
Date.
Date 4/1/1981.
Yes.
Now their service, husband's service, has been regularized or approved in the year 1997. By the order of the authorities.
Khalasi, you said 4/1?
This is my initial appointment.
4/1?
81.
81. And approved in?
1997. Date of 21st of February 1997.
What is this approval?
The approval regarding regularization who was continuing as temporary Khalasi. Government had accepted their service as regular service.
From work charge employee to regular.
The husband of the petitioner retired on
Yes.
31st of March 2005. Husband of the petitioner expired on 22nd of July 2010.
July.
22nd.
21st.
And this approval of regularization, when did it culminate into actual regularization? In 97 itself?
97. With effect from 81, who were appointed prior to 91, their service has been approved, meaning thereby. So in that list, the other petitioner also, my lord, included. My husband name also there in that particular approval letter. I am covered there.
In 97 letter?
97 letter. Serial number, it figures my husband name.
With effect from the date of 4/1/81?
Yes, prior to 1991, in my case, 4/1/81. So, application made by husband as well as the petitioner, but pensionary benefit has not been given. Automatically, my lord, approach before the tribunal. The tribunal initially, my lord, did not pass any interim order. There was a direction for filing affidavit, but they have not filed any affidavit to that effect. Ultimately, the impugned order at page, my lord, last but one.
Let them file the opposition then.
Subject to correction. Whether it is required or not, it is absolute lordship. But kindly see these judgment covered by these lists.
They must have an opportunity because you said they have not filed there also. If they had filed, we could have proceeded. But since they have not filed, let them file it.
Technicalities.
Yes.
Covered by judgment.
No, we have understood what you are saying. Otherwise, they will say without giving opportunity on the first.
Can be.
Yes.
Short date, it is covered by 1 week, it can be, I believe so.
The sum and substance of the petitioner.
number 4.
Hmm?
This one number 4 affidavit.
Yeah. তার একটু নামটা কোথায় পাবো?
নাম কোথায়?
আপনি তো short.
Is down. কারো আছে? Okay. Yes. He is the busiest counsel in this case. Because of this system.
কোডটা আছে?
আমার 3
32 এর চলছে। হয়ে গেল তো 31 তো হয়ে গেছে।
না 30 হলো।
না 31 হলো এটা। 30 তো টাইম হয়েছে।
Both sides are here, then we can proceed. They will fix it in the meantime. What is the next? Call the case number 32.
Kindly turn to page 150.
150.
Brief. And will kindly come to 151. I'm just facing the relevant questions of the order. Thirdly, Mr. Banerjee submits that the transfer being the prerogative of the employer, the respondent is eligible to exercise his discretion. Mr. Banerjee has further pointed out that transfer committee as constituted with the order dated March 25, 2025, which the petitioner has grievance, has been subsequently dissolved. When my grievance was there, it was alive, and there would not be any cause of action. Considering all these, the Honorable Court was pleased to pass this order at page 150. Having heard all the learned counsel for the respective parties and after filling of records, kindly underline this. It appears that firstly, the tribunal being on vacation, the instant matter has been filed before this court, which cannot be said to be beyond provisions of law. The petitioner has alleged a biased and arbitrary transfer order being issued against him. The issue is required to be dealt with after filing of affidavits before the learned tribunal. This court does not enter into the merits of the matter. The entire issues, including that whether the interim order transfer and petitioner should be stayed or not, is thus being relegated to the tribunal, and there was an interim order granted by the division bench. Now, we now go back to the tribunal. Now, kindly see the order of the tribunal. Will I have the
157.
157 is the order of the tribunal. The relevant would be at page 158. Appearing on behalf of the state respondent, Mr. Banerjee, defending the action respondent party, submitted that such transfer was routine in nature and issued for administrative reasons. There was neither any malafide intention. These are all on verbal by the learned lawyer, nor any vindictive motive behind such an action. Mr. Banerjee also pointed out that as evident from the transfer order, it was not only the applicant, but a total 25 other employees holding the same post as Industrial Development Officer were transferred. He has also pointed out that the applicant has been serving in the same place since 2014. Therefore, it cannot be said that he was filed out and his transfer was vindictive in nature. On being asked by the tribunal whether the administrative authorities had accepted the recommendation of the Employees Association proposing such transfer, this was my specific challenge, which found favor with the High Court at the initial stage also. The Banerjee, having exonerated purported document appearing at so and so, categorically refuses. Well, the factual aspect, how to manage lawyer. In first place,
dispute that document and learned tribunal accepted. Court specifically held that it should be decided on application. It categorically refuses the allegation of the applicant that terms of the document is a fake document. I would like your lordship to direct them to produce the entire file. That will show which is fake and which is not. It's a Mukherjee for the respondent number 5 and 6, Tarakada. That is the private respondent, but who is the mastermind to ensure the transfer order. I am concerned because I am his political rival.
Right, respond number 5.
5 and 6.
Notice has been served. Oh, you're already a
Now the learned tribunal, the single member dismisses my petition. The first question is, when the question of fact is concerned, how could the tribunal rely upon the statement at the bar?
There was no opposition filed. Did you file an opposition there?
Yes.
Before the tribunal?
No, blood. First day. On merits, blood. But may I say one thing? My learned senior friend, blood, has pointed out the page 152. Blood, during the exigencies, tribunal was closed. But my point was, when I appeared in that matter, blood, WPST, my point was, unless it is filed in the original, filed in the department as original application, no WPST cannot be entertained. But however, my lord, Mrs. Justice Rai Chattopadhyay, her ladyship, was pleased to grant them a limited interim order and refer the matter to the tribunal. But my learned friend has skipped over the page. Kindly, trouble to come page 153. 153. That is the continuation page of the Honorable High Court. The third paragraph from top. Let the tribunal take up and consider the present application of the petitioner being not influenced with the whatever narrated above in this order on the day. So therefore, independently, and decide independently. So it was decided independently. 26 candidates have been transferred. It is a routine transfer. Out of them, 22 have already joined. This particular person.
Which organization is this?
This is our industrial development micro.
Small and medium.
Micro, small,
MSME.
MSME. Yes, and what has happened? Well, I will show to your lordship. The document. Lordship, kindly see this document. Director Deven Joseph. The Alipurduar district.
No, nothing like that, sir. Sorry, I don't.
The magistrate has said.
I don't believe in these things.
Out of the six already nil. There is no administrative failure.
Already?
6, 4, sanctions and 3, and there's nil. Yes. Nil. No, nobody. Unless he joined, the administrative breakup there. And your lordship knows, is a condition of service transfer. He is here, 14 years out of his 11 years out of his 17 years service. The 11 years he is here. 11 years out of, and 22 candidates already transferred. Joined. And I am drawing your lordship's attention. 110 একটা 110 দাঁড়ান না, হ্যাঁ 110 গভর্নমেন্ট অর্ডারটা দেখুন 110 আর দাঁড়ান কথা জানেন। If your lordship kindly turn to me, lord, there is also, my lord, also to mislead the court. But 110, my lord, kindly trouble to come to 110. Objection is 110 of the petition. 110 of the petition.
Whether they have misrepresented, whether your actions are in accordance with law, how these issues can be decided. That is the only issue that he has raised.
Only, my lord, your lordship kindly see.
We are not on this.
No, this document has not been placed before the authority.
Therefore, we are saying how things have been decided.
My lord.
How it can be decided like this?
General,
without-
General Secretary, General Manager. He is not General
We
Manager.
don't know. We don't know. He may be the
My lord.
maybe not entitled to
My
any
lord, my
relief.
lord, my lord, my lord.
We are not on relief. But when the High Court says that in view of this allegation, you have to look to the records, filing of affidavits, then how the tribunal has decided without affidavit?
No, but
That is not to be ignored.
No, that is not.
The observations are to
No,
be ignored.
observation, Lordship, kindly see.
Not the requirement of filing
At the
affidavit.
same time, High Court has said.
High Court, the requirement of filing affidavit is there in the act itself.
My lord, your Lordship is right.
Then,
but at the same time, my lord, kindly.
We don't know why you have been so impatient before the tribunal.
I'm only, my lord, I'm only, my lord, only, my lord, I beseech to your Lordship, kindly, my lord.
You should have filed an affidavit and
that's
dealt
right.
with the issue.
But Lordship, kindly see, my lord, at the same time.
No, we don't know.
No,
There is nothing before
High
the
Court's
tribunal.
order, High Court's order.
There is nothing before the tribunal.
No, High Court's order was there.
High Court's order, we don't know whether they have misled. There is
High
there
Court
is no
has
affidavit to the
High Court
controversy.
has said independently.
How many times you will say that? Saying it twice doesn't make it better. You have said that already.
My lord.
That we have understood. The issue is when the High Court says after affidavit, why the tribunal should decide without affidavit. Even that observation is to be ignored. Is that your submission?
But affidavit, Lord, High Court has said.
Just now we have read it, sir.
My lord. देखिए 150.
Come to page 153 top. In view of the alleged bias and arbitrary transfer being issued against him, the issue is required to be dealt with after filing affidavit. Why this should not be done after this issue? Maybe the same result will, we don't know.
But Lord, can I say one thing?
Therefore, there is nothing to be said. The requirement of them approaching the court of first instance in terms of decision of L. Chandra Kumar for having the benefit of a reasoned decision is not there. There is no affidavit, there is no application of mind by the tribunal. But we are very reluctant to interfere in a transfer order, and I am being very open on this. But when there is a direction of the High Court division bench, the tribunal will overlook. That is the only issue.
But Lord,
nothing else. He may not be entitled to any relief.
My lord, kindly see. My lord, your lordship kindly consider when he has come, the stand release order was issued.
We don't know.
No,
he will suffer the consequence. We are not saying anything. Why it should not be considered? Maybe he will succeed. Everything has to be undone. Maybe he has to suffer the consequence. We don't know. We don't know. We are not at that stage. You did not allow it to be done in this way. You could have asked the tribunal that, look, there is...
Traveling to your lordship, I have understood.
Then,
but at the same time, but at the same time, Lord, I have understood.
Otherwise, at least this bench, we don't interfere in transfer matters.
But I have understood what is
as a normal, unless something glaring is shown.
I have understood what is the mind of the court. At the same time, Lord, only Lord, your lordship kindly consider the situation of the administration.
How long you will take for filing affidavit before the tribunal?
দাঁড়াও না কথা বলছো কেন জজ সাহেব একটা কথা জিজ্ঞাসা করছে within 10 days, Lord, we shall file. And Lord, lordship kindly.
We are not going to say anything on merits.
That's right.
Nothing.
Only one thing I'm placing before your lordship. Lordship, may Lord record my submissions. Lord, is a routine transfer. 26.
We don't know. There is no affidavit for you to say these things. And we don't like the system of handing documents. Anything should be on record, then it is to be considered.
A stand release order has been passed. Your lordship
We don't know.
interfering.
We will must take.
No. The year after. Huh? Thereafter stand release order is passed.
See, all right, we don't.
Your lordship is not interfering.
You are saying that he has been released from wherever he was.
Yes, kindly record that.
You have any objection to this?
No.
So the release has been passed. This is a fact.
Yes, thereafter. That was state, but thereafter.
And that release has been
after
passed.
19th June.
You need not say everything thrice. We understand in once. Yes. So it has been issued and you are required to go somewhere.
Yes.
Wherever some posting has been given, what is the date of that order? One? 159.
Last page, last page. Last page of the petition.
As soon as the tribunal dismisses it, they release me. They are so high.
Not high.
19th of
Out of 26, 22% already joined. Yeah, that doesn't mean. And you are 11 years here. If you are,
I thought that's
yeah.
I just question cannot be compared with the man that
Yes.
was filed. Yes.
So this was not assailed again. This transfer was not assailed.
No, that is not.
Transfer, that was.
No, this was not assailed before the tribunal.
Release order is not a transfer order.
This 19-6 order has
My
not
lord is
been
asking.
assailed.
No, this was after the tribunal dismisses my petition. High Court was pleased to grant the stay. Kindly come within 1 week.
Limited stay.
Okay.
Limited stay.
See petition I person party proper to stay in this order dated May 27, 2025.
Very well.
Therefore, Lord, the situation as it was there before.
There was a release order prior to this also.
Yeah. That was.
Where is that order?
That is not. 137.
So the posting place has changed or it has remained the same?
Same.
Order that came one that
Very well. Take down.
And your lordship kindly record all these service papers, books have already transferred to the North Bengal.
We don't know. We are not going to record
On
anything.
instruction I'm saying. On instruction
You may say whatever you want.
lying vacant.
Call the next case.
Yes, suffering. 33. Yes, another hobby.
हमारा भी सुनवाई कर लिया जाए सर, वारंट करके पूछिए, ध्यान देगा हवलदार महेश या तो फिर सुनवाई कर लिया जाए उसका, केस को क्लोज किया जाए.
Item number 33, my lord. But there was some dispute regarding the filing of the wakalatnama since the client could not get the no objection of the erstwhile advocate. But today he was supposed to be present at the time of call to produce the documents.
Please, can you please repeat your submission? What are you saying?
My lord, item number 33, my lord. In this matter, my lord, there was some difficulty in filing the no objection wakalatnama since the erstwhile advocate is not traceable. My lord, the client was supposed to be, the petitioner was supposed to be present today, my lord, to file the documents, the communications he made with the erstwhile advocate, my lord. But I'm requested to pray for an adjournment since my lord, he is an government doctor in the government hospital, my lord, he could not get leave today.
Petitioner's counsel.
My lord, petitioner, my lord.
Petitioner is unwell.
My lord, he could not get leave, my lord. He is a doctor in a government hospital.
Oh.
My lord, if the matter can be taken up Monday as to be mentioned, my lord, he can personally produce the documents, my lord.
On Monday, you want it on Monday?
My lord.
As prayed.
My lord, the several communications made by him to the tried to communicate the erstwhile advocate.
Why communication and you will not file it on affidavit?
On affidavit, my lord.
Then file it. It will come on Monday.
Item number 34.
Lordship, Mr.
I am for the petition, Lord. I am only paying some accommodation for only not Lord.
How much?
Only one day, Lord.
Not today. Call the next.
I am grateful. Lord.
35.
Come for the respondent, my lord.
For the petitioner, my lord.
Last direction ki chilo? Opposition is
In the last occasion, my lord has pleased to direct to file the affidavit of opposition within 20th June, my lord. We have received the opposition yesterday evening, my lord. Yes, lordship, and another
Activity in opposition.
lordship, another
okay.
36.
Thank you.
Take the can 3.
Can 3.
Yes.
Only one humble submission. There is a prayer for modification of an interim order. But there is a
There is a prayer for modification of the interim order.
Vacating the interim order.
Which interim order?
But there is an earlier interim order passed on the 8th of 2nd of August 2024. Page 24.
What? Doesn't have jurisdiction. What do you want? Why you have given this?
Administrative order in the list like that application is aware for modification go to the same date.
Yes, it should.
But I'm asking for vacating of the interim order because Lord, if it has to go before the other bench, then Lord release Lord the. I tell your Lordship, the difficulty is that this.
No, whether we should go into the merits, we are asking you as a officer of the court in view of determination. We are not seen. Show him whether we should enter the merits or not. First, let us be clear on.
I have my independent application.
No, is we are asking.
But in so far as vacating the order is concerned, it is purely for the Pali municipality being unable to Lord be administered. This gentleman.
We are understanding, but the point is, do we have the determination to do it? Otherwise, it will be a exercise in futility. Therefore, we are asking you. If you have urgency, we can release it if it is to go before another branch. Today itself.
But technically speaking, the notice does not include vacating. It says, Lord, modification.
Modification means it means review. Vacating means in a way review.
Therefore, modification. That's why I want.
No, that it has. Or even otherwise, it should go before the same. Unless the bench is not available. Both the judges are very much.
The bench is not available.
No, bench means the persons comprising the bench, they are available. What is?
May I address your Lordship 2 minutes? I
Can
have an independent application which is made by the Department of Finance, Government of West Bengal.
Yes.
I am neither asking for modification or anything of that nature, my lord. I am asking for leave of your lordships to
We sent on Friday. Yet. Yes, take down.
But just one humble request. Lord, in case your Lordship finds that your Lordship is unable to take up Lord the application filed by Pali municipality, then Lord, my prayer is that Lord, this is a matter relating to transfer. Lordship, Lord, kindly hear out the main matter, because for main matter, Lord, we need not vote, because this bench has to be constituted, and for constitution of this bench, Lord, this application can't be heard for a long period.
Then application is not pressed.
Not pressed, you kindly take up the main matter.
Then you argue it.
your lordship hear out my application.
Then you argue it. We'll fix it in the next week.
Your lordship can hear up my application.
We'll fix in the next week. We'll hear out.
My application is very short. Your lordship kindly
We'll see. We have not gone to the merits.
No, I'm not.
Today there is no time of.
As far as my application is concerned, your lordship need not get in the merit. Mine is very short point.
Yes.
So may I just tell you, lordship?
This writ petition is filed by the state.
No, this one is Department of Finance, State of West Bengal. I filed.
By the employee.
Employee. Issue of transfer. And the transfer. What? Just give us a brief background. What happened? Just very briefly. So his transfer was challenged before the tribunal.
Account officer in Pali. He was with the post of account officer.
No, so it's been received. No, it's been received.
Anyway, if you are not pressing that application, then we'll fix it in the next week.
No, my application.
Yes.
But I have a certain amount of urgency. If your lordship fixes the next week, I will not say anything.
But if Lordship kindly keeps it any day convenient to Lordship, because there is some urgency. Because I'll tell you,
Your convenience. You give us your convenience next week.
Tuesday, Wednesday, Thursday, whenever convenient to Lordship.
You give us.
Any day. Tuesday, Wednesday, Thursday, any day.
Wednesday, if it's all right with your Lordship.
Wednesday is what date?
Wednesday, I'll give your lordship.
Wednesday, second. That can be
Take it up on Thursday. Thursday ka date.
Yeah, second.
We'll take not second will not be possible. Thursday will take.
Thursday, very well. 3rd July.
Which is the application for modification will record today?
3. Can 3.
When the
Initial ये ছিল on edible oil তো initial injunction was on edible oil. দাঁড়া 173 কি বল 173 এটা
Item number 37, 38.
My lord, this is my application in contempt. If your lordship kindly comes to a lordship's order, my lord, the suit was in relation to a passing of action. And my lord, the learned district judge at Barashat was pleased to pass an order of injunction restricting the order of injunction only in respect of edible oil. My lord, aggrieved by that, we preferred an appeal. My lord, the appeal court order was presided over by Justice Tandon and my lord Justice Prasad, my lord, which is at page 174. 134. আমার page different কি করে? My lord, which is at page 134. The operative portion of the is at page 157. 147. There was an appeal and a cross appeal. My lord, if your lordship kindly takes the order, my lord, if your lordship kindly takes page 134 once, this was the order which was passed by the additional district judge at Barashat. The plain 134, my lord, it is, yes, my lord, that's the order. Yes, my lord, that's the High Court order. Here, my lord, your lordship will find what was the order which was passed by the Barashat court. The plaintiff is the appellant in the instant case, assailing the order number 44 dated 5th of August 2023, passed by the learned additional sessions judge Barashat in title suit number 3 of 2016, by which order of temporary injunction was restricted to edible vegetable oil till disposal of the suit. The appeal is taken out at the behest of the appellant on the score that the court should not restrict the temporary injunction in respect of edible vegetable oil. The matter was heard, arguments were made. Now, my lord, your lordship will kindly come to your lordship's order, which is at page 147, the operative part of the order. 146, last two line of order. My lord, if I may trouble your lordship with the last two lines of page 146 also. Last line. It appears that apart from edible vegetable oil, other food items are traded with the trademark Rishta, which acquired a distinctive mark associated with the appellant. And even if the respondent has subsequently registered the said mark, cannot get away from the clutches of the passing of action. It is evidently clear from the documents relied upon by both the parties in the said proceedings that the appellant is the prior user, and therefore there is no justification in restricting the order of temporary injunction to edible oil vegetable only. The order of injunction is modified to the extent that the respondent shall be restrained from passing of its product by use of the mark Rishta by selling, stocking,
food items and edible oil till disposal. So this covers everything. Now, if your lordship kindly takes page 148. They are still advertising on their website about rice and other food products despite your lordship's order and in clear violation of your lordship's order. Your lordship kindly takes page 148 and 150. They are still offering, selling, and your lordship will kindly see at page 150. It is on Amazon. My lord, they were served. The affidavit of service is on record. If your lordship kindly takes the contempt of rules, contempt of courts act, the rules, the Calcutta High Court rules, my lord, appendix 1, form 1. Beseech your lordship, my lord, to issue a rule against them. My lord, they are still using it even after filing. Even after filing, we have taken out.
They are appearing in the suit.
No, in the suit.
They are now appearing.
Yes,
They
yes.
appear.
So why don't you serve a copy on the counsel representing them in the suit? Let them appear.
Say that I have no instructions so far as the High Court is concerned.
No, we'll direct you to serve on him, serve him personally, come back.
Beseech your lordship.
We understand what you're trying to say. You want us to issue a rule. We are saying let him come. Let him come. Just let him come. You serve a copy on the advocate.
Enough opportunities have been given.
We don't think so. There is an affidavit of service. Last day we recorded that it was recently served. Maybe they are making a
The lordship, so
arrangement.
you can serve once more, my lord, and then
You serve on the learned advocate also, both modes.
the difficulty over there, you could say that I am not instructed in this matter.
How do you know what he will say?
But
He may come on that basis. We don't know.
Then in that event, may we serve the learned
We cannot
advocate
presume.
as the respondent.
That is what we are saying. This is exactly what we are saying. Stop. Yes. There is no appearance.
Item number 2.
Yes, I am for the petition one.
Next. Hence, we have already heard you. We will pass the order.
Everything has been done. Only the points taken or the, that is already away.
Sorry.
Item number 39.
Especially every person, my lord. My lord's contempt application. My lord was pleased to pass an order 11/12/2024. My lord, kindly see the operative page number. Issue was regarding motion order, which is
11/12/24 order. Yes, you have communicated.
reminder.
Where is the communication?
Annexure. Page number 32 and 43. Communicated.
Serve a copy. Let notice be served. Call the next.
Going to retire in this year only, my lord. Record will be higher.
Item number 40.
Last occasion, Lordship was directed to serve the copy of the my lord, other legal heirs, my lord. My lord, we have already, I have personally tried, my lord, the address is not found, my lord. The department has tried, my lord, twice, my lord.
Department?
Department has tried twice to send the communication, but my lord, it is returned, my lord, unclaimed, my lord.
So what is to be done? Without notice, we should proceed.
Otherwise,
Tell us.
otherwise,
You have to find your respondent defendant.
I wrote a letter to them.
Who are they? They are not they are not state authorities. Then what they will do?
We don't have them.
Then what is, you tell us what is to be done. What is the proper procedure? You tell us. By saying it has not been done, that doesn't help you. You have to tell us what is the procedure, what is to be done. When they are not available at the address, then what registry will do? Unless you know the whereabouts, where is the question of registry doing anything?
If they have, if they know the address, then they can submit us the.
How they will know the private respondents?
1, 2, and 4. I am appearing on behalf of 1, 2, and 4 substituted defendant.
Yes. You cannot. They have no liability to do this.
We have no relation with her.
See, you are in a court proceeding. You are not discussing something. Therefore, we are asking you, what is the procedure? Tell us. They know why they will not serve this. We are not sitting in a casual discussion.
Paper publication, my lord, alternative way.
We are asking him what he want, how he wants to find his respondent. You have tried thrice, but you are submitting 10 times the same thing. You will have to. What can be done? You know the procedure. What is the last known address?
Post office Raghunathpur, district Purulia, West Bengal, pin 7.
Which respond number, sir?
Added.
Let respond number 3.
My lord, in envelope, written as refused. So that is good service.
Where is it? You have filed it.
My lord, and my lord,
Where is it? Where should we find it in the file?
not there, my lord. If possible, my lord, I have filed the affidavit service.
You have to file it.
Yes,
How
I-
you can?
my lord, the copy is there, my lord. Kindly, if
No, you file it, then we'll consider. That council.
Forty-one.
41, my lord, I am for the petitioner. Read by Mr. Bikash Ranjan Bhattacharya, my lord. Read by Mr. Bikash Ranjan Bhattacharya. He is engaged in part at matter, I think, court number 17, my lord. So, my lord, I am making appeal to a lordship. Kindly adjourn the matter today and tomorrow. Because this matter is complicated.
Forty-two.
Stalemate.
Well, I was not in the matter, but after perusal of some documents, it appeared it's a very peculiar case. Very peculiar case. An employee who joined the service as a substitute by impersonation. Disciplinary proceeding was initiated. And that went up to the statutory forums up to appeal and review. Now, the employee died. Thereafter, his son has made an application for substitution.
The proceeding could not be complete.
Complete. But it was remanded to the appellate authority for decision anew. Now the son has made an application in such a situation. Now, whether this question an order on error apparent on the face of record on the date of death of that incumbent who by impersonation joined the service as substitute can be gone into, that was agitated by filing an application for review.
Review of?
Review of the order.
Remanding it to the
Yes,
tribunal.
and allowing the return to be substituted. Now the review was rejected on the ground of limitation. Now both the orders were challenged.
Here.
That is not correct.
But whatever I have said.
Order was passed. But final order was passed. Your lordship can come to page.
You will have your say. You will have your say. Don't get impatient.
Whatever, I was not in the matter, whatever record.
No, but we'll go by the records as they are.
Now, on the last occasion, lordships have been pleased to ask my Gandhi Junior, satisfy us as to how both the orders can be challenged in the WPCT. The order initially passed and the review order. Both the orders. Possibly, kindly find me out that. Actually, kindly come to page 34. Lord, kindly first come to page 33. The order.
Please give us 1 minute.
চ্যালেঞ্জ করেছে। Page 30, if your losses kindly see, the order passed by the tribunal.
Page
30. চ্যালেঞ্জ করেছি তো এটা আমরা।
This is the order review of which was sought.
Yes, that is at page 58.
Yes.
Huh? Page 58. Kindly come to page 58. Order of 4th November 2019.
33 ট্রিট করে দিন। এই অর্ডার পুরো 33 তে শেষ হচ্ছে। বেশ 33 তে শেষ হচ্ছে।
বাবা আমি রিপোর্টটা দেখাচ্ছি।
অরিজিনাল অর্ডারটা দেখাবেন।
ওরা দেখি তো বললাম বলিস তো কেন দেখাবো না সবই দেখাতে হবে। Page 30 report. $619 order, no?
690 stat order.
वो तो cat order की हुई। Death. So the order, original order is of 13/6/2019.
Yes.
By the tribunal. Now, the father of the present incumbent who is added He expired on 10 September 2013. Therefore, under service jurisprudence,
Mother was the employee.
yes, father was an employee who joined the service as a substitute by impersonation. That is why disciplinary proceeding was initiated.
Both the orders of
Comes the moot question, well, only one thing. And if my lords want me to satisfy lordship, on the next day I'll be doing this. The question is, under the service jurisprudence, if a disciplinary proceeding for alleged ground of misconduct and the discipline and appeal rules is initiated, and the contract under the service jurisprudence between the employer and employee that ipso facto gives rise to the initiation of a proceeding, whether the son has a right to be substituted in such a case. All service matters are simplistic matters of contract, except on the ground of payment of back wages to the incumbent who died in hardness or thereafter, the son has a right to come before the court. So, the date of death is extremely important of Ganesh, the father, on 10 September 2013.
So the applicant in OA 1695 was the son.
Originally the father. That was remanded.
No,
and the father died, Ganesh Thakur expired on 10 September 2013.
Therefore, we are saying in
this order, which is passed by the tribunal,
in OA
challenge before your lordship.
OA 1695 is after his death.
Yes.
So it was filed by his son.
No, this.
He has died in 13 and this OA is of 2010. So during pendency, he has passed.
This was since on substitution by the son, Dinanath Thakur.
Substitution was already done.
Yes. Now kindly come to the moot question, whether after the death of the father on 13th September 2019, this particular order at page 30 is a nullity or not? If it is a nullity, nullity or fraud, these questions can be agitated in any proceeding. Page 49, my lord, is the review application. Page 49 is the review application.
That has been dismissed only on limitation.
But if it is not,
so this direction and paragraph 7 of the order at page 33. At page 33, there is a direction in paragraph 7.
Remand. Yes.
Paragraph 7, it says, we direct the authority, disciplinary authority,
yes,
give due opportunity to both sides.
So how the son
reinstate the applicant. So this applicant by this time is the son.
By this time is the son. This is totally non-consideration of record. Total non-consideration of record. The order has been passed. This is a question where is the locus standi of the son to participate in a remanded disciplinary proceeding?
Prior to this also some OA was filed.
Prior to this, yes, my lord, I am told another OA was filed. That is in respect of 10 and 11 of 2003.
Which page can we see the order?
Ten and 11. But I understand 10 and 11, there are two, not annexed, but there are two separate ways filed by the Ganesh Thakur, the original incumbent, and another applicant who were facing the similar disciplinary proceeding.
No, that we have seen because the tribunal has said we'll pass the same order in this case.
Now,
But therefore,
question, if your lordships kindly consider whether the son has a continuing cause of action.
we have understood what you are saying. What we want to ascertain is, even if we accept your submission, is there any earlier order governing the rights of the parties? Whether it will be a futile exercise, what is the effect of setting aside this order? That's why we are asking you, when he has approached the tribunal earlier, at what stage his right crystallized? Did it culminate into an acceptance of his culpability?
Earlier approaching the tribunal was definitely and not by the incumbent son Dinanath Thakur.
That we have understood. But so his right has been determined at what stage? Whether finality to the punishment was attached or it was left, so from where?
He was punished all along. Now, if you will also kindly see the order of remand, that is at page 30.
Page?
Page 30 onwards.
No, this order does not consider.
Para 3 at page 32 of the order. That will not reveal everything. It transpires from the record that Ganesh Thakur and Sukumar Das being agreed by the dismissal.
So therefore he was successful in the earlier way. His dismissal was set aside and it was remanded to the appellate authority.
Yes, here in this order, it was remanded. Now comes the moot question, if it is remanded in respect of the case of Ganesh Thakur, the father of the present incumbent, whether there is any continuing cause of action of Dinanath Thakur's son to participate in the disciplinary process.
No, that is not the question. The question is in para 3, the tribunal has remanded his father's matter to the appellate authority.
What is the date? Kindly see, my lord. The date of the order is, date of this particular order is 13 June 2019.
No, sir. Please read para 3 again.
Yes. I am reading the
08, 10 and 11 of 2003, there was a remand to the appellate authority, not in these proceedings.
First, kindly read 3 and 4.
3 and 4.
Yes.
4, since there was an apparent error on the aforesaid direction in the second round, when the appellate order was challenged by Sukumar Das, another applicant.
Yes.
Applicant in OA number 11, this tribunal modified the order passed to OA number 10 and 11, respectively, to the extent.
Therefore, we are saying, let us see the issue in clarity. Where are these orders? What will be the result of setting aside of this order? Will it ultimately give right to arise in his favor or will it not? We must know.
I will have to check the entire record.
We have asked your instructing counsel earlier also. We have been asking her repeatedly that she says, I don't have anything. How can you say that?
She is now saying that only the petition is provided, not the orders.
As a counsel, anyone can say that.
Mr. Mojumdar may have those documents. Definitely, as a counsel, we must
the employer will have all the records. The employer must have been party to all these proceedings. It's not open to them to say that we don't have anything. How can they say this?
May I just make one submission with great
Yes.
respect, subject to correction? Even if in a proceeding that is of 10 and 11 of 2003, some observations were made. How is it that thereafter it reached up to the appellate authority and the higher authorities imposing and maintaining the punishment, and then final order is passed for remand in page 30 of remand for page 30. Sukumar Das had approached the tribunal para 5 through OA number such and such, filed by Ganesh Thakur, applicant number such and such, substituted by Dinanath Thakur's son, due to death of Ganesh Thakur during pendency of way number 1695 of 2010, who deserves identical relief. So where is the question, my lord, of observing in para 5, he substituted in his service jurisprudence, my lord?
No, but what is, that's why again and again we are saying, ultimately the position will revert to what? Even if this order is set aside. After all, even if it is held, even if we, after hearing him, we don't know, but even if we hold that this is an order in futility, then what will happen?
Yes, your lordships are aware that when in quasi-criminal case or any service jurisprudence
Yes.
matter, when the incumbent dies, the matter ends. So the contract in service jurisprudence ends, except that if some retirral dues or any
So
dues,
therefore we are saying, what was his status? What it will revert
he
to
was
which?
a temporary employee who entered the service as a substitute by impersonation.
That you have said, but what was the finding of?
Then kindly place it on its
What is the finding holding the field
Exactly, I understand.
till prior to passing of this order?
Exactly, I understand.
That we have to see.
Yes, that we will have. You will
Then only we can proceed.
kindly place it on the
You also tell us.
Ask the department to produce the entire records.
My lord, let me play. Lordship has gone through the 3 and 4. Instead of deciding the matter, appellate authority, my lord, the tribunal was the order of the appellate authority and the disciplinary authority, and remanded the matter to the disciplinary authority for further consideration. In the meantime, original my lord, appellant had died.
No. Prior to this, appellant had died. Prior to this order, appellant has died. Don't say in the meantime.
However, my lord,
What do you mean, however? That changes everything. This order was being passed when he was no more. Therefore, even if the date of death is not in dispute. That is not in dispute.
son is substituted.
Son is already substituted prior to passing of this order. He has died much before this.
Yes.
At least 3 years before this.
What the original order was issue?
What order? This order we have already seen. We don't need to go through it again and again.
This is the
Please.
consent degree.
Consent does not improve the situation if the applicant, if the employee is deceased. What consent will do? Consent will not change the law. Therefore, we are asking you, what was the position prior to passing of this order? Whether your rights crystallized in your favor, or whether it crystallized in their favor prior to this. What was the position? If we set aside, after all, some consequence will follow. What is the consequence?
Lordship kindly consider, if they, my lord, come to the question that I am not the employee, I am not.
What do you mean if you are not? Can
not
you say you are the employee? Where is the question of if and but?
entitled to get the subsistence allowance?
That they are not saying. That they are not saying. You have heard what they are saying. They are saying you cannot be proceeded against. There is no master-servant relationship between you and the.
Yes. Then if it is
Therefore, this tribunal's order is a nullity. That is what they are saying. So, if it is a nullity, what is your right?
my lord, I shall get the my lord.
So, we don't know. That is what we are asking you. What is the position prior to passing of this order? Whether as a result of this order being set aside, you will get nothing or you will get something. That we want to see. What will be the consequence?
My lord, original order.
If the consequence is nothing, then we'll see what order has to be passed.
Yes.
If the consequence is against you, then we'll see what is to be passed. So we must see the records. An issue has
at all in any time was confirmed. Confirmed, then other benefits will.
Then they may be entitled to many benefits. Otherwise,
Exactly. I'm getting.
Because at this stage, my lord, no punishment is in the on record.
so we'll find out. The moment the background is placed, we will find out.
The order was quashed. Remanded back to the disciplinary authority.
That's
Now, my
true.
lord, the disciplinary authority order has not yet been passed because I was not.
A temporary employee who joined as a substitute
Question
by
does not arise. That question was not
whether-
taken at the time of original hearing of the
Not
application.
question of law, your lordships are aware, 1977.
And after
Supreme Court,
consenting,
page
the order was
5
passed.
can be taken at any stage of the proceeding.
And review application is dismissed for the limitation.
Next.
43,
I am for the respondent, my lord, 43. I am for the respondent, my lord.
At the outset, I have been engaged in this matter subsequently. I must admit that this is not happily drafted because the reply rejoinder has not been annexed with the writ application. However, Lord, the issue involved in this application is, Lord, the question of seniority. Seniority, in this sense, Lord, the petitioner reply file. But the applicant before the tribunal asked for relief of seniority from the date the seniority was cancelled. On, I think, certain rules, but the factual aspect of the thing is that the applicant in the tribunal was an aspirant for a group B officer's post. B. So, my lord, the method of examination was that paper 1, paper 2, and subsequently, after passing this examination, interview. So, my lord, paper 2, he was allowed. In paper 1, the authority questioned that there is some technical difficulties in the question. So, my lord, that paper 1 was cancelled after a lapse of around 1 year and a half.
That paper was
cancelled.
Cancelled. Paper 1.
Yes, and re-examination was taken.
Or 1 only.
1.
The result of 2 was maintained.
The re-examination was conducted. Subsequently, what happened, my lord? The question arose that in the next batch, this examination was taken for the period 14-16 vacancy year.
And re-examination was in a subsequent year.
Re-examination, by that time, a fresh vacancy year was considered, but the result of this re-examination was not published. And the petitioner participated in the subsequent examination, both paper 1 and paper 2, and he
Both papers.
Both paper in the subsequent vacancy year, and he qualified.
And what happened to the re-examination of 1 paper?
Now he is claiming that I appeared into 14-16 examination, and I qualified in the paper 2, but not in paper 1. The re-examination was conducted, but the fact remains that without disposing of the same or without declaring the same, because the second batch of officers have been taken, and naturally the seniority position has gone down, the juniors have gone up, and I have been gone down.
So you the applicant appeared for the re-examination of paper 1.
Yes.
He participated in the subsequent process also, and the benefit of the first paper, which re-examination is not being given to him.
So that was cancelled after the lapse of 1 year. the re-examination papers.
And after cancellation, he participated in this. Where is the cancellation order?
That is in page 30. Firstly, my lord, before I answer to your lordship, my lord, kindly come to page 35 in the rating. No, next second. Because the petitioner is in the 30% group. There are the petitioner is in, there are two groups. One is 70% vacancy to be filled up from the seniority come merit come seniority list, and the 30% limited departmental examination. So the petitioner falls in the second group, limited departmental examination.
Obviously, he is appearing for exam, so it has to.
So in 30, my lord, lordship kindly see page 31, red mark. For completion of that process, the petitioner subsequently participated in the next selection process and he was selected. Now he is asking the seniority since the authority failed to declare the result within the stipulated time. So, my lord, he is asking that his date of function should be from the date he appeared in the first examination, 2016. And the tribunal's direction, my lord, Honorable Tribunal has passed the order a re-examination for paper 1 may be conducted if required. Well, we don't require any further re-examination. Well, the last paragraph, having noted no report of large-scale malpractice, corruption, nepotism, favoritism, we are of the confident opinion that the respondent should be directed to complete the selection process at the earliest. Similarly, the subsequent re-examination paper is to be published or
And where is the notice of 9/2/2018? Whereby this process was cancelled.
Made, but subsequently, my lord,
No, there is a prayer for quashing of that notice in the OA. How you are saying?
2015 দাঁড়ান এক সেকেন্ড এত খারাপ পিটিশন আমি কখনো করিনি ধর
Prayer B is quashing of that notice 9/2. How you are saying it has been issued later? It has not been.
circular is not annexed with this, but I
You
have
could not annex. That is the impugned order in the OA and you could not annex.
the order in the original application.
Yes.
Tribunal, but I find that order.
So what is the order which has been interfered with? Unless we see, how can we? Yes. You have filed a reply in the tribunal.
I submitted before notice and this is not happening. Neither the reply nor the return have been annexed. To PCT. Not the application is
Has the impugned order been taken note of in the tribunal's order? 9 to 18 order?
no. It's been taken note of, but the question is, Miller, the tribunal has been pleased to direct to conduct the re-examination of paper 2, paper 1. Miller, that is the last part. Miller, in the second page of the order, Miller, the second paragraph, the third paragraph. As the applicant chose to participate in the examination held on 16/11/2018, he decided not to file any representation as per order of the tribunal. However, no result was published and no reply was given to his representation by the authority. Being aggrieved, the applicant again approached the tribunal, which disposed of by its answer. The main plank of the argument advanced by learned counsel is that the impugned order is a cryptic one without disclosing reasons detailed. Respondent authority cancel the written examination for promotion to the post of assistant in facing under limited department education quota. Department never followed the master circular of railways because within 4 months that is to be done. Similar, it was cancelled.
No, your impugned order is not there.
Yes, that's not
How you have filed the writ petition?
filed earlier. Lord, I have been recently engaged and the impugned order is not there. I have to
'Let supplementary affidavit be filed.' Let a supplementary affidavit.
supplementary affidavit.
File a supplementary.
44.
Where is the respondent?
I am for the petitioner. Several times.
Last day you have handed over the supplementary affidavit. Last day. On 12th.
On that day.
On 12th.
Yes.
He is not here. Let him be here. Not today. See if he is here tomorrow. Maybe he is filing a reply. We don't know.
45.
I am for the petitioner on behalf of Mr. Monesh.
Not today. As prayed by learned.
কালকে করবেন 46 because
Earlier it was 46. Recently it has not been.
তার সঙ্গে ওটা আছে but may I request one thing also subject to consent is given by my learning senior but item 45 46 similar in nature both the matters in yes land losers case appointment in land losers in item 45 I have submitted one compilation of documents 45 the matter no, no, please the matter just now it has been adjourned. In item 45, I have submitted one compilation of document which contains various schemes framed by railway board. And the order passed by different division bench of this honorable court. And perhaps this honorable court is a fifth bench to us. So there is a very complicated question now arises. Which orders would be followed by the appointing authority, railway board? In land losers cases, there are 4 orders operating together, and this should be the fifth bench. This honorable bench, my humble submission, kindly hear out these 2 matters together. Since earlier matter has been adjourned, so kindly tag these 2 matters and we shall.
You give the compilation to him.
We shall hand over it. Kindly give it next week so that my learned friend can also prepare. No, no, for your preparations. If you are ready, then it's all right.
I'm ready. I'm ready. Tomorrow. I'm ready tomorrow.
And one more thing, as I'm told, in item 46, my lord was pleased to direct us, so of course, on the basis of my submissions, that we wanted to get the verifications of the academic qualifications in my learned friends matter. So we already sent to the chairman of the recruitment cell, already sent one letter to the concerned West Bengal Council for verifications of the academic qualifications, but it has not come to us as yet. But hopefully next week we'll get it. So already 1 week have gone. So kindly give us.
So if they have taken steps, then let us see what happens.
Already we have taken steps.
Yes.
Already.
Tomorrow they are after. No. If they have sent, then let it wait for some time.
It may be kept on record.
If your education is verified, then what will remain?
Then one question goes.
Yes.
One obstruction goes. If qualification is correct or genuine, one obstruction is good.
Previously 1 month time they have taken. Then 1 month time. Then 1 month.
You are interested in early hearing or you are interested in some action being taken?
No.
Unnecessary. Why do you have to?
Already we have sent this data.
When they are saying they have taken action to verify your, then you want to take it up tomorrow. What for?
Let this matter be adjourned for this week.
Yes. As it is submitted by the learned council.
Like 46 দুটোই থার্ড
47
Lordship, Mr. Sukumar Bhattacharya appearing for the Union of India, praying for not today, Lordship. His legs on court number 23. The matter is going on, Lordship. Good.
48
Thank you.
The matter where on the last occasion I had the occasion for the first time to submit your lordship before lordship that during the pendency of the main matter, the contempt proceeding has been initiated by the tribunal, and my lords have been pleased to grant us liberty that till 2nd July, this matter, they shall proceed with the contempt. Monday, my lord, I shall have to undergo a minor operation. So
My lord, I am for the respondent.
Yes, you are
Except
appearing, but
respondent number 3.
we are virtually seeing you.
Yes, my lord, what happened? I am submitting one thing, my lord. The identically placed person has already got the relief. Identically placed person has got the relief. They lost the matter up to the Honorable Supreme Court, my lord. But in the same list, when the order of promotion has been made, one Mr. Siddiqui has got the same. And his case has been appealed up to the Honorable Supreme Court, my lord. The tribunal relied upon the similar
I
circumstances.
shall satisfy your lordship on the interpretation of the jurisprudence, whether the Supreme Court judgment has any application on the interpretation of jurisprudence on the next date.
Murthy case. Murthy.
Yes. No.
My lord, they have implemented
He has
that order.
labored very hard in this matter. Prior to your appearance, he has labored very hard.
Yes. He has instructed me. He has instructed me partially, but there are voluminous documents. So after 5th, kindly place it any day.
Yes, he has to undergo a surgery. You want to object to that?
Minor surgery.
No, we are asking Mr. Chatterjee that he wants to object to a date
Myself, Mr. PC Das.
PC Das, your name
Yes.
is showing on the screen as Chatterjee.
Actually, I am taking help of his laptop, madam.
Yes. So let him have his surgery. Let him come back. We'll hear you. Yes.
My lord, kindly fix a date, my lord. My lord, what is the date, my lord?
9th, 10th. What date suits you?
9 July.
Wait. Let the petitioner.
No, let it be on 8th.
8 July, my lord.
Yes.
Yes,
Any problem? You have any problem on 8th? You have any problem on 8th, Mr. Das?
My lord, instead of 8, let it be on 10th, my lord. I have some problem.
10th.
10th, I have some difficulty. Why is it, my lord?
No, he has some. If you have difficulty, he is also entitled to difficulty.
Yes, my lord.
7th, it may be 7th.
No, he's saying 10th, then let it come after 10th. 11th or 14th, whatever date.
11, lordship.
14th.
11th.
11th.
As jointly prayed, ma'am.
Yes, my lord.
And my lord, the interim order may be extended.
Interim order. What is the date of the interim order? The interim order.
There will be a function at Jalpaiguri that is about the circuit bench matter.
There will be
circuit bench matter. That is so your losses also may be there and we shall also be there. So
let us see.
Let it be then on 14th.
14th we have said, no?
14th.
Oh, 11. No, there will be no problem. 11, there will be no problem.
Great one.
দেখা যাবে।
Lordship, in item number 49, I beg to appear for the petitioner. Lordship, I am appearing for the petitioner.
Yes, not today.
Lordship, Lordship, may I make a small submission in this regard? My lord, they are taking adjournment for past 2 months.
Yes.